The court held oral argument for the second time on October 12, 1988. And of course, this time, the court focused on the issue of whether or not Runyon v. McCreary should be overruled. Following oral argument, William Brennan, who was the leader of the liberal wing of the court, started to strategize. William Brennan was actually quite famous for being very strategic, and he actually began to write his opinion even before the conference began. And he had a particular strategy that he was going to adopt, and this was very strategic because Brennan really believed that Runyon was correct. Brennan was a liberal. He was on the court when Runyon was decided. He was in the majority when Runyon was decided. And so he believed that Runyon was correct. And so he could have made that argument. That was certainly something he could have done, in fact, because it's what he actually believed. But Brennan was a very strategic justice, and he tried to make arguments that would draw a majority of the court. And he wanted to win rather than to necessarily get everything that he wanted. And so he decided in the conference to argue something different, something that was designed to appeal to perhaps Anthony Kennedy and perhaps some of the other more conservative justices. Brennan's argument was, well, Runyon might have been right. It might have been wrong. It's arguable. So his argument was that it was debatable. Could have been right, could have been wrong, but his argument was if we were wrong in Runyon, Congress could have overturned our decision. As we've talked about earlier in the semester, when the court is engaged in statutory interpretation, when it's interpreting a law that was written by Congress, if the court gets it wrong, Congress can overrule the court simply by passing a new law. And Brennan argued that if we had been wrong, Congress would have passed a new law to correct us. Since they didn't do that, then our decision must have been correct. So this is a different argument than Runyon was clearly correct. Rather, Runyon was arguably correct, but congressional silence means that we didn't get it wrong the first time around, and since we are supposed to follow precedent, the rules of precedent say that we should uphold Runyon v. McCreary. So this is a more modest argument. It is an argument that is designed to not merely attract liberals, but to also attract perhaps moderate votes as well. So this was the argument that he made. And in his first draft, he phrased it this way: precedent must surely mean that we will not revisit a close question of statutory interpretation that has been settled in a carefully considered and detailed opinion joined by 7 members of this court, and that has been reaffirmed many times since. Our decision in Runyon has become an important part of the fabric of civil rights protections. It's become the basis for the hopes and conduct of members of racial minorities who see our interpretation of Section 1981 as both a powerful symbol and an essential practical tool for combating discrimination. So the court then went into conference, and William Rehnquist, of course, got to speak first. And he says that he thinks Runyon was wrong and that indeed it should be overruled. No surprise there. Rehnquist was the one who wanted to re-argue this issue. So he argued that it should be overruled. But he then hedged his bets, saying, well, but it's possible that these two cases are so different from each other that it might be possible to rule against Brenda Patterson, but not overrule Runyon. Now, what does this mean? What this means is William Rehnquist just wants to vote against Brenda Patterson. He doesn't care how he does it, he just wants to vote against her. And so he says, well, maybe I don't have to overrule Runyon. Maybe there's another way I can vote against Brenda Patterson. But in any case, he was a little unclear about whether he was actually voting to overrule Runyon or not. They then went around the room in order of seniority once again. Brennan, of course, voted that Runyon was right, so he voted to not overturn. Byron White, however, accepted Brennan's argument. He said Runyon was wrong, but since Congress didn't overturn it, we shouldn't overturn it either. So Brennan's strategic argument was successful, at least in the case of Byron White. White, if you'll recall, was one of the more conservative justices. He was a moderate conservative, but he adopted the liberal Brennan's argument. Then Marshall, Blackmun, and Stevens all voted. They were all liberals, and so they voted to uphold Runyon. So now, 6 of the justices have voted, but 5 of them have voted to uphold Runyon. So Runyon will not be overturned, it will be upheld. But then, O'Connor and Scalia have an opportunity to speak. They are normally conservatives, and they too accept Brennan's argument. They agree with White and Brennan and everybody else that Runyon was wrong, but it shouldn't be overturned because of the rules of precedence and the fact that Congress didn't overturn it. Then, the biggest surprise of all, it comes to Anthony Kennedy, the most junior justice, and he says that Runyon was simply correct. So he adopts the most liberal argument possible, and this was a real surprise because, of course, it was Kennedy who provided the 5th vote to re-argue the issue and to consider whether or not to overrule Runyon. But ultimately, he decided that Runyon was correct. So he didn't even adopt the more moderate position that Runyon was wrong, but it shouldn't be overturned. He adopted the very liberal position that Runyon was simply right. So what this meant was that Brenda Patterson has won the first issue. The question is, should we overturn Runyon v. McCreary? The court has now voted no, and in fact, it was ultimately a unanimous decision on this particular issue because Rehnquist ultimately changed his mind. He voted with the majority, and so the court decided 9-0 not to overturn Runyon. That was a victory for Brenda Patterson because what it meant was that her suit, that the Civil Rights Act of 1866 did apply to McLean Credit Union. Unfortunately, of course, this wasn't the end of the case because the court still had to deal with the first issue that they originally were supposed to consider, and that was whether the Civil Rights Act of 1866 in employment discrimination, does employment discrimination equal discrimination in the making and enforcement of contracts? If you'll recall, that was the first issue in the case that the court never decided because they decided to hold the case over for a year to ask whether Runyon should be overturned. Well, they decided Runyon shouldn't be overturned. So now we're just back to square one, and the court has to deal with this other question. And we'll talk about what the court did with that in the next lecture.